Okay, so let us start. See, today we will be having two topic, that is topic number 12 and 13 of administrative law in the discussion. Okay, so we'll talk about these two topics, right, in detail, and we'll try to make a sense that what type of questions from these topic comes in exam. Okay, so that will be our today's topic, right? So let us see. We have topic number 12 and topic number 13 from the law optional syllabus. Okay, topic number 12 and topic number 13 from the law optional syllabus. Okay, now someone is asking the difference, right? The difference I will talk about in GS paper 2. Okay, not to worry, right? Let us here only talk about the law optional. Okay. Yes, so let us see. These two topics, as you already know, are basically from the administrative law. Okay, administrative law. Now administrative law, only we have three topic in our syllabus, right? Obviously administrative law is a huge field, but only three topic are there in our syllabus, right? But that doesn't mean that those three topics are, somehow less important or something like that. Okay, so they are very, very important topic, right? Even if we do not have any, less amount of topic, but still the question that comes in administrative law is quite larger. Okay, so we'll go into the sub details, sub topic, that it has to be read in the topic given. Okay, someone is asking, this series will be done in the entire paper in 1 and 2 of the syllabus. Yes, I hope so, but I have a batch starting from 15th of from tomorrow itself, right? Law optional batch. So I will reduce the number of days that I will be taking, right? But I will complete the whole syllabus. Okay, not to worry, I will explain the whole syllabus. Okay, hopefully in 30 lectures I will complete it, right? So this is almost 10 lecture, right? So in 10 lecture I will complete around the whole constitutional law will be completed in part A, will be completed in around 12 lectures, right? So 24, around 48 lectures, but I will try to reduce it to 30 lectures. Okay, that I will try to do. Okay, now let us go into detail of these topics one by one. See, but again I am telling you, it might take, someday I will take off, I will make it 3 days a week once my law optional batch starts, because I have to focus more there. Obviously you may understand that. Okay, but I will complete it. Okay, I will complete it. Okay, see, when we are talking about subtopics, right? So the subtopic is basically, now please do not unmute yourself, please. I have unmuted muted everyone, so please mute yourself. Okay, do not unmute yourself. Yes. Now let us start with this. See, when we say principle of natural justice, the most important, the syllabus part, principle of natural justice, emerging trends and judicial approaches. Okay, so that is the one part of the syllabus, right? Topic number 12. Then we have delegated legislation and its constitutionality. Okay, so that seems to be quite simple topic, right? But obviously it is not. Okay, so let us see, delve into detail that what are the subtopic that need to be studied, right? So first let us talk about principle of natural justice, right? So the first subtopic, if you look at this subtopic, then you can see the administrative law sometime even not mentioned, the questions have been there, right? So what do you mean by administrative law? What type of administrative law it is? What is the need of the administrative law? Nature of the administrative law, right? Like in the case of need, I have given in notes as well, right? So in a very precise manner, that the nature of the administrative law is ultimately to give justice, right? It will sort of act as a justice delivery system arising out of the working of administrative machinery. Okay, so the administrative law origin also has to be understood, right? You must be knowing that Napoleon had this book, right, that he collected everything, and in France basically the administrative law came into being, right, and thereafter it evolved from there to everywhere else. Okay, so administrative law is one of the system of civil law system, right? It is not a common law doctrine, it is basically civil law doctrine. Okay, so administrative law, right? Similarly, you have to understand its importance vis-a-vis constitutional democracy like ours, like constitutional democracy like India, right? You have to know that why administrative law becomes plays a very, very important part, especially in the case of India. Okay, so that part has to be studied, right? It is basically the philosophical aspect of the administrative law. Okay, so that definitely has to be studied. Okay, thereafter you have to study its usefulness, right? Usefulness in the terms of what? So usefulness, that suppose we have an administrative system, then does it act as a replacement of court, or it is sort of giving more and more support to the court? Okay, so in that sense the administrative machinery or administrative law has to be studied. Okay, so even if it is not in the syllabus, there have been question on that. Okay, sometimes they connect this administrative law with constitutional governance. Okay, so that is a separate topic that I will discuss tomorrow, actually not tomorrow, on Monday, right? Tomorrow there will be no class, right? Tomorrow is Friday and new batch is starting, so I have to focus more there. Okay, so from Monday I will take it. Okay, now then so do remember that you have to study administrative law philosophical part, even if it is not mentioned in the syllabus, because there have been questions on that. Okay, then we will go to the actual syllabus, that is your PNJ. principle of natural justice, right? And if you are a law student, or if you are not a law student, then also principle of natural justice is always a part of judicial system of our country. Okay, in fact, it is one of the, this whole principle is based on the book, right? That why a person was ate apple, Adam ate apple, right? So a question was sought from me that why you ate apple. Okay, first the explanation was sought from them. Okay, so that is a very very important point here, right? Because it is something which the religion also says ki, okay, natural justice is a principle which is ingrained in the human psyche. Okay, so the natural justice principle must be adhered to. Okay, so in that sense you have to understand the purpose of natural justice. Okay, because even if no law is there, nothing is there, still the natural justice will apply. Natural justice have become so much important principle that is now a part of one of the philosophy of constitutionalism as well. Okay, so the fundamental right or administrative procedure of any particular country given in constitution or otherwise must have in them ingrained the principle of natural justice, right? We will see also one of the case, very famous Tulsi Ram, where the court has held that the article 14 by default subsumes within himself the natural justice principle. Okay, right? So they have ingrained, they have read the natural justice principle into the constitution. Okay, so that is again a very important part that you have to understand. Similarly, why it is inviolable with respect to administrative law, right? Now if you think about it, administrative law do not have a set statute, right? So the only thing that controls or limits the power of administrative law is PNJ itself. Okay, so without principle of natural justice, administrative law basically makes no sense. Okay, so PNG is a part and parcel of administrative law, because PNG only leads to a situation where a person can actually get justice within the domain of administrative law. Okay, because without PNG, because we do not have any CPC, we do not have any CRPC or evidence law. Okay, so only thing that protects a person getting justice before the administrative system is PNG. That is why I have written here inviolable connection. Okay, so administrative law cannot function without PNG. Okay, so that philosophical aspect has to be handled. Okay, that is very very important aspect. Okay, so do remember it. Then we will go to the rules of PNJ. Okay, now you must have seen 3 rules. No one shall be the judge of their own cause, rule against bias, right? So multiple, there are sub parts of it as well, right? So what I will suggest you that you read each rules completely and sub part as well, right? And at least remember 3 to 4 cases, right? Because what happens while writing answer, there suppose there is a generic question, right? Audi ultram partem, discuss, very generic question. Now in that case, obviously you have to know the sub rule in the Audi ultram partem, right? Reasonable opportunity should be given, notice should be given, and multiple sub parts are there, right? Now from each sub part you should at least be able to recall 3 to 4 cases, right? Now you can pick and choose any cases actually, right? Now if you look at standard textbooks, they have huge number of cases for a huge sub part of related to the principle of natural justice. That is not required in our UPSC exam. They don't ask question like that, right? They do not ask one strain of natural justice. No, they simply ask natural justice. Mostly the philosophical one. I will see the question also, not to worry. Then you will realize that what type of question actually comes. Okay, so pinpoint it and make it like I like in optional batch I dictate these are the 4 cases. Just remember it and write the the ratio of those cases. That's it. Okay, so that is how you should also approach with this. Okay, so please remember that. Then you come to the rules of PNJ, its evolution in modern days. Multiple times this question has come, that what is the modern approach of natural justice, right? Or what have been the recent development with regard to natural justice, right? So apart from these 2 major principles, the recent development have been that its connection with constitution, right? Its connection with positive discrimination doctrine, referred to article 14, it connection with article 21. Okay, so these were the modern development in the principle of natural justice with respect to the Indian Supreme Court decisions. Okay, so that is something you should try to understand and try to get a hang over it. Okay, because without that obviously you will be not able to solve the questions. Okay, so you have to understand the modern and progressive approach with regard to natural justice principle. Understood? So that is a very very important thing to study, and you should study that. Okay, then after studying this modern and progressive approach, you have to come to the exceptions, right? So 2 things are there basically, exceptions and consequences, right? There are certain category of exceptions, right? You must be knowing, right? Like in the case of emergency or where the inquiry is not feasible. There is a very interesting case law also. Some boys were punished in the administrative machinery of a college because they were doing something with the girls hostel, right? Then in that case the court held that okay, it is not practicable to hold inquiry. because of the social prevailing situations, right? So the principle of natural justice may be done away with. Okay, so those are the exceptions, right? So that exceptions has to be studied. Yes, Navneet is very correct, that the Rajendra college case, that is very correct. Okay, so that has to be studied, that is very, very important. Okay, then you have to write the consequences, right? What will happen if it is not fulfilled? Okay, so one is the when it can be waived away, and one is that if it is not fulfilled, what will happen, right? So obviously automatically it will violate article 14, and the whole proceeding can be declared, it is voidable, not void actually, right? So it is voidable at the option of the party who is basically being wronged. Okay, so it is voidable at the option of that party, right? So in toto, in the very beginning, then ab initio it will be not void. Okay, so that is the crux of the consequences of non-fulfillment. Now also that you can waive your principle of natural justice requirement, like in the case of fundamental right you cannot waive it, right? But in the case of principle of natural justice you may choose to waive it, certain principles, right? Not all the principles. Okay, so what will happen, what will be the consequences if you choose to waive it? Okay, so those are the nitty-gritty of this consequences of non-fulfillment of PNJ that you have to study. Okay, so that is a very, very important aspect of PNJ. See, the whole concept of PNJ is to give justice. That is very, very understandable, a very simple thing, right? Now what are the thing that is connected with the PNJ? One aspect, meaning, scope, case laws, fulfillment, exceptions. So these are the 5 things that you have to study about the PNJ. Okay, that I have already mentioned about. Okay, so these are the 5 things that you have to study about PNJ, nothing else. Okay, right? That is why I told you that even if it is a simple, a simple looking topic, right? This judicial approach, how the Supreme Court have connected it with our constitution and emerging trends. Okay, so that has to be focused, right? So you need not to study the whole book on PNJ, right? Only the subtopics that I have given you, simply study that, it will suffice. Okay, then you will come to the second topic, right? Invariably there is one question, right? Second topic, right? The question, what is delegated legislation, right? So first, the meaning of delegated legislation, right? Delegated legislation basically means that if you are a legislative authority, or if you are a legislative body, then you have delegated that power to someone else. Okay, we can find multiple examples of delegated legislation, right? In the olden days, in the British days also, right? CRPC 144, the most used example of delegated legislation. Okay, right? Then the purpose of it, what purpose did delegated legislation solve, right? So it basically introduces flexibility in law, right? Because once you make a law, you cannot possibly comprehend all the things related to that particular law, not possible at all, right? Because ground application of every law is different. Okay, so you have to trust your executive by giving them power that, okay, you mold something, right? You mold the law according to the current prevailing circumstances, right? Because legislature is not omnipresent, they cannot be present everywhere and say, okay, these are the things that you have to do, these are the things that you have to do. No, right? So that is why we have a need for delegative legislation, right? That is the purpose of delegative legislation. Okay, so that is the one point that you need to understand. Then method, how delegation is done, right? So there are multiple methods, rules. You must have seen any law, and there is any, in any law, if there is any section which says that the government may make rules in this regard. Now once this word rules comes, it means the legislation is being delegated. Okay, or as per rules, right? Something, right? Or the terms and condition of service will determined by rules. Okay, suppose there is a constitutional body, or administrative body, right? And that body, one thing is written that the terms and condition of the service shall be determined as per rules. In the law it is written, right? Now that rule is basically delegation, right? Constitution also provides lot of delegation, right? Multiple time we will see that this will be done as per the act of parliament, right? So it is delegating actually parliament to make law. Understood? Sometime executive delegation is also there in the constitution, right? President by rule will determine this. Okay, like for an example, in the case of this National Commission of Scheduled Caste and Scheduled Tribe, right? 338A, B and C, right? You will see 338, 338A and 338B, right? You will see that there is a provision that the tenure and everything of the chairman and everyone will be decided as by the president. Okay, so what is basically constitution doing? It is delegating the power, okay, to the executive, right? So delegating is everywhere. Okay, so that is what you have to study in the method of delegation, by which way delegation occurs. Okay, by making rules, making standing orders, right? Multiple methods. Okay, a very simple list, you can actually simply see and understand it. Then the most important aspect of delegated legislation is basically constitutionality of the delegation, right? You must be knowing a very important case in Delhi, right, where It is a very complex case, right? A law was made, right? And in those time we used to have Part A and Part B of the states, right? Part A and Part B. So Part A was the state which were directly under control of British, and Part B was basically the state which was princely states actually, right? So some law were made for Part A, but simply by an executive act it was extended to Part B, right? Later on the act was amended, the original act which was extended was amended, and then it was again extended to Part B. Then the question arose that can legislature do it, right? Can legislature trust executive to do this work, okay? Or for each time the extension is required, the legislature have to pass a new law, okay? Then the question arose and advisory opinion was obtained in reference to in Delhi cases, okay? And in advisory opinion, Supreme Court 5-judge bench, it was a very initial case, all the major judges sat on the bench, right? And they gave a very interesting judgment, and the best thing about the judgment is that 5-judge wrote 5 separate opinion, right? So still people are deciphering what is written in the judgment, what is the crux of that judgment, right? So what I will suggest again, that read each and individual judges judgments and pick up 3-4 lines from it, okay? According to Justice Gajankar, this is the wording. According to Justice Mukherjee, this is the wording, okay? That will give you ample armory to write in the exam, okay? So I will suggest you to take out those things. Then meaning then when we talk about constitutionality of delegated legislation, then the only thing is that they cannot delegate essential function, okay? Now whole administrative law related to delegated legislation basically revolves around this word essential function, that essential function cannot be delegated, okay? Then there is theory. One very important theory is basically policy and guideline theory, right? It means whenever you are delegating something, legislature is delegating something, there must be some guideline within which that delegation will function. You cannot delegate unbridled power, right? You cannot parliament cannot make law that okay, whatever the Aditya Tiwari will say will become a law. No, they cannot do that, right? What they can say that okay, if whatever the Aditya Tiwari will say will become law, but within this particular guideline, okay? So you cannot have unbridled delegation. It has to be channeled, it has to be coped up, okay? It has to be controlled delegation, okay? So that is the policy and guideline theory in short, right? Multiple times there have been direct question, what do you mean by policy and guideline theory, okay? So please remember that. Then focus on delegated legislation vis-a-vis taxing statute, right? Mostly the question of delegated legislation, in fact any court any question comes before the court only if the money is involved, right? So the whole Kesvanand Bharti, it was related to land, right? Land is a very costly affair, okay? So without money the good lawyers do not come before the court and argue the cases, right? Only if money is involved, okay? So whenever there is a taxing statute, right, a law related to taxing power, right, then only the people come, right? Then only the constitutionality is violated, okay? Then you must have seen there are multiple laws actually, especially all the law related to import and export, excise duties, they are always delegated, okay? Right? So when a taxing statute is delegated, in certain cases court have simply said that okay, the preamble of that particular law is sufficient guideline. Sometime court have said that no, preamble is not a sufficient guideline, you have to have a more better guideline. Sometime even a word have been used, okay, it is sufficient guideline, okay? So there are multiple case law related to it, right? So do read that, okay? So vis-a-vis taxing statute, delegation has to be studied, right? So that is very, very important part, okay? So do remember that. Then the control mechanism, how the control can take place, right? There are multiple method of control: publicity, prenatal, postnatal publicity, right? Then there is laying of requirement. What are the laying requirement, right? There are sometimes concept of conditional legislations, okay? So everything has to be studied in the case of control mechanism. Especially read this publicity requirement, right? Because sometimes the publicity can be waived, and sometimes the publicity is very, very important. Okay, that is the before presentation of rules, it must be published in local newspapers, right? If I remember correctly, there was a case in which it was not published in local language, right? In Gujarati newspaper, the court said that whole delegated legislation is actually invalid. Okay, so that is one thing that you should Yes, Harla versus State of Gujarat, if I am correct. Yes, Navneet is saying is correctly. Okay, right? So see, these are only 2 topics, right? But it can be subdivided into 8 subtopics, right? इसलिए मैं कहता हूँ administrative law, even it seems to be very simple, but it is really in depth. You have to go and study. Understood, right? So if you will see any standard textbook, these 8 topic can be covered in 2 chapters actually, right? So do not read anything else, only these 2. Then let me give you some of the notes or case laws that is important. See, here again I have given you certain lines that you will write in the exam, the philosophical basis of administrative law, right? See, purpose of PNG and administrative decision making. Today, the bulk of the decision relating to personal or property rights of the people come not from the court but from the administrative agencies, right? What are the things that you can cite? You can cite about proceeding before the appellate jurisdiction, right? Appellate jurisdiction of taxing statute. We have appellate taxing commissioner. Similarly, in the case of land also, the first jurisdiction is decided by the SDM, right? Then we have land tribunal. Okay, in some states we have land tribunal, some states we do not have land tribunal. Okay, and these are basically administrative machinery. In the case of labor law, almost out of 7 layers, the top 3 layer is basically administrative machinery. Okay, so that is what actually I am pointing it out. Okay, now any book you can study Yaswin, right? And I will suggest Sathe, VN Sathe. What is the name? Yes, Sathe, SATHE. You see that that article that I told you in the beginning in the first class itself. Okay, in de facto law website, you see there is books, right? In that I have given a very detailed list of book as well. Okay, so you go through that. Okay, Yaswin. I mean, it is for everyone. Please go through that. Okay. Exercising judicial power. Sometimes the task of adjudication is merely incidental to administration. Okay, so that is something very good, right? See, sometimes what happens that when you are making a decision, right, that in the case of that decision, that decision itself acts as a judicial proceeding. Okay, so that is what actually I was talking here, and this paragraph refers to, that it is simply an incidental to administrative process, right? You are basically performing a judicial function, but you are not, in that sense, in larger sense, you are doing only the administrative function. Okay, but you are doing judicial function as well. Okay, so that is why it is written here, it is incidental to the administrative machinery. Okay, like in the case of pensions, right? Once you retire, government do not give you pensions, right? You must have seen this CBI case. There's Alok Verma. Still, his pension has not been released. Okay, and he is trying to find a writ petition in the Supreme Court for the release of pension itself, right? So government do not treat you very nicely once you go away from the government. Okay, even if you are a senior most IPS officer, that doesn't mean anything actually. Okay, similarly. Yes, IP message is also good. Yes, somebody is asking me, that is okay. IP message, but VN Sathe, this V Sathe actually I like it better, right? More lucid language and more systematic and close to the UPSC optional. Okay, so that you can study. Okay, now administrative decision making or administrative adjudication is a byproduct of an intensive form of government, right? Now, what is the meaning of intensive form of government? The government is performing every function in the society. Now, we have a socialist economy, so the government is in the economy, government in controlling monetary policy, government is controlling the competition, government is controlling the market. Okay, so there are multiple administrative structure, right? So when you have an intensive form of government, the government is interfering in each and every aspect of the market or even the society, then obviously you will be having a plethora of what? Administrative machinery. Okay, so that is what actually have been referred to, intensive form of government, right? Minimum government and maximum governance, right? Right, so that doesn't happen, right? After this government itself, the number of administrative machinery have actually increased rather than decreased. Okay, so much for minimum government and maximum governance. Okay, consequential socialization of law, right? Thus causes for evolution of administrative adjudication and delegated legislation are the same, right? So somewhere it basically comes together, right? So when you have an intensive form of government, you need to have administrative machinery. Now once you have administrative machinery, you must give them certain form of delegated legislation so that they can adjust that administrative machinery according to the practical needs of administration. Okay, that again comes the governance part. Okay, so that one thing you have to keep in mind. Similarly, there is one of the another argument in support of administrative machinery, that the judicial system cannot give to the people that quantity and quality of justice which is required in a welfare state. Now again, I doubt this statement, right, being a part of judicial structure, right? But still, I will say that that is somehow true as well. Okay, because the court goes into very much nitty-gritty. Time of delivery justice is wrong. In administration, if you know the right guy who is making the decision, and if you can give them right money, then obviously the decision will be very, very quick, right? Otherwise, it is again as bad as the court system itself. But one thing in administrative machinery is okay, that suppose there is a payment that you are a contractor and there is a payment that has to be released from a government department and they are not releasing in a certain time frame, right? Then what you can do actually, that you can file a writ petition, at least mandamus to impel them to give you payment. Okay, so that sort of thing happens. Okay, so administrative machinery, at least you have one more solution, right, if something is not being done in administrative machinery. Okay, so that is one thing you should keep in mind, quite interesting actually. Then exception to the rule of natural justice. Now there are multiple exceptions. I have cited only one, right, in this particular case, Raslal Yadav versus State of Bihar. Application of principle of natural justice can be excluded either expressly or by necessary implications subject to the provision of 14 and 21 of the Constitution, right? So it means you can waive it by absolute implication, by or necessary implication, like that case of this Rajendra College case, right, that the inquiry is not practicable. Okay, but even if that is waived, still the requirement of 14 and 21 cannot be waived. Okay, so the court have read into the principle of natural justice 14 and 21, right? So if you waive 14, if you waive natural justice, but you still have to follow 14 and 21. Okay, so that is the recent or new development of natural justice. देखिए जो topic में है ना, top में, see, emerging trends, right? So that is one of the emerging trends of natural justice. Okay, so you have to keep that particular thing in the mind. Okay, right? Then effect of non-observance, right? One is the waiving and here is the non-observance. Okay, see, the court are unanimous that a decision rendered in the violation of rules against bias is merely voidable, not void, right? And voidable at the option of the party who have been wronged, जिसको नुकसान हुआ है natural justice नहीं follow करने से, ठीक है ना? Suppose I am administrative authority, I have not followed natural justice and I have given a decision. Later on I said कि okay, decision I have given in their favor, so I cannot go and say that okay, I have not followed the natural justice, so I recall my decision. That cannot be done. Okay, so it is voidable at the option of the person who is basically being wronged. Okay, so it is not void ab initio. The aggrieved party, see, the aggrieved party, those who have been wronged, may thus waive his right to avoid decision, as where the timely objection is not vain, even though there is a full knowledge of the bias, the right to object to it. Okay, so if you by necessary implication have waived it, then it is waived. Okay, so that is the one thing that you should keep in mind. Very important case, Manak Lai versus Dr. Prem Chand. Okay, so that case you have to actually understand. Okay, then now again I have given this line again, that fundamental disagreement among court and jurist as to the effect of the breach of the rule of fair hearing. Okay, so sometimes they accept it, sometimes they do not accept it, right? So they read the case laws in both aspects. Okay, while in the cases where the court have accepted it and the case where the court have not accepted it. Okay, so read it in both aspects. That is very important. Now this Tulsi Ram case, very important case with respect to natural justice principle. Now why it is important actually, because this case can be cited not only in this in this particular delegated legislation, sorry, PNJ, but it can be cited in Article 311 related to civil servant as well. Okay, it basically infuses that article. It have basically read that PNJ basically the Article 311 is basically one of the manifestation of PNJ. Okay, so the Article 311 within themselves combines principle of natural justice, right? So it is basically case related to the relationship between Article 311, that is civil servant, and there this doctrine of pleasure, yes, and the other things as well, right? And PNJ. Okay, see here, inquiry under this clause and clause gives constitutional mandate of principle of natural justice. Okay, it gives constitutional mandate. Okay. Ordi alteram partem rule by providing that the civil servant shall not be dismissed or removed from the service or reduced in the rank until after an inquiry is made. Okay, and the inquiry must follow the principle of natural justice. Okay, that is why this is a very important case. Similarly, the principle of natural justice are not creation of Article 14 of the Constitution. Article 14 is not the begetter of the principle of natural justice, but is their constitutional guardian. Right? Actually, an argument was made from the opposite party that Article 14 actually ingrains principle of natural justice. So if something satisfies Article 14, that it can be assumed that the principle of natural justice have been followed, right? Opposite दूसरे तरीके से argument दिया उन्होंने, right? The court said that no, Article 14 no doubt contains principle of natural justice, but that doesn't mean that once Article 14 is satisfied, it cannot be hit by the principle of natural justice. No, not at all. It is simply the guardian of the principle of natural justice. It is not the begetter. ठीक ना, पैदा नहीं किया उसने प्रिंसिपल नेचुरल जस्टिस को. ओके, इट इज सिंपली अ गार्जियन ऑफ द नेचुरल जस्टिस प्रिंसिपल. ओके, अगेन इट इज अ वेरी इंपॉर्टेंट लाइन that you must remember when there is a question regarding constitutionality or constitutional relationship with principle of natural justice. Okay, so please do remember it. Similarly, now these are simply judgment lines, right? Ratio from the judgment itself. Okay, then Article 14 applies not only to the discriminatory class legislation but also to arbitrary or discriminatory state action. Okay, violation of rule of natural justice result in arbitrariness, which is same as discrimination. Okay, so that is again the connection. Okay, when you are discriminating, by default it is arbitrary. Okay, and once it is arbitrary, it offends Article 14 as well as the natural justice principle. Okay, where the discrimination is a result of a state action, it is violation of Article 14. Okay, administrative machinery, both Article 14 as well as principle of natural justice. Therefore, a violation of principle of natural justice by a state action is a violation of Article 14. Understood, right? So this is a very, very important ratios of this particular case. Okay, so do remember that particular case. Okay, there's one more case of Mangni Ram, but obviously that I am not writing here, but you do read it. Not, it is not Mangni Ram, it is something else. No, not Mangni. The Dhanilal Jania case, that is I think in tort, state action interference with the state action for sovereign and non-sovereign function. No, that is a different case. I'm very sorry. Now let us come to the delegated legislation, right? Now 2-3 concepts I have given with regard to delegated legislation, right? So let us see here. First is the need. Why do we need delegated legislation, right? See here, the vast complexities of social and economic condition of modern age and ever-growing amount of complicated legislations, right? Especially in the case of SEBI, right? If you go to the SEBI Act, right? It is not much as longer as the rules framed under the SEBI Act. Same thing happens with the Company Act. Okay, right? So it becomes so complex that you cannot practically write everything down in the legislation. It is simply impossible, right? So what to do in that time, right? So in that time, what you can do, you can come up with delegated legislation. You can trust the officers and entrust them to mold the law according to the need. Okay, so that is the one thing, complicated legislation. That is called by a progressive social necessities and have made it practically impossible for legislature to provide rule of law which are complete in all their details. Not possible, that I have discussed. It is impossible to provide all the detail. Delegation of some sort therefore has become indispensable for making law more effective, adaptable to the varying needs of society. So you could do sub points में लिख सकते हैं. Make it more effective, make it more adaptable to the needs of society. Okay, तो वही मैं कहता हूँ कि जब when you read a paragraph, you should pinpoint when you write down that as an answer, right? Then you can write, okay, this is the first point, this is the second point that I will write down, right? That is the process of note making actually. Okay, so when you read it, okay, like in class when I dictate, so I dictate note by note itself, right? That you have to practically present in the exam. Okay, you can do it by here itself, right, if possible. Then traditional concept of understanding, right? So there is a very famous and this doctrine of delegatus non potest delegare, that whatever have been delegated to you, you cannot delegate it further. Okay, very common law doctrine, right? Like king cannot delegate anything, right? Because he is the sovereign one, right? So common law doctrine. Okay, rule making authority cannot delegate its power unless the power of delegation is contained in the enabling act, the act which is giving you the delegation. Okay, so it cannot be further sub-delegated. Okay, so basically parliament act as a delegation, parliament have the delegated power to make law by the constitution, or parliament can delegate further, right? So that was the question that arose, that the parliament, is it itself is a delegated entity, right? The constitution says to parliament that you make law, or parliament is the enabling entity and they can delegate to someone else, right? So our view was that no, parliament is itself a delegated entity. Okay, the Indian view. Okay, so it can delegate further only within the contours of constitution and that case law related to in re Delhi case, that they cannot delegate the essential function because they themselves have been delegated the power to make law. That doesn't happen in the case of UK, right? There the parliament itself is sovereign, right? So in that aspect, our concept little bit varies. Okay, now again there is a division of opinion among them, right? So the majority of the judge of 5-judge bench says, some of says that no, parliament can be attributed to holder of some of the part of sovereignty, right? So they cannot be considered as a delegated. That is why I told you in Re Delhi case, 5-judge bench, 5 separate opinions, very tough to get the ratio of it, but still. Okay, so that is the basic concept related to delegated legislation, right? So please remember that. In Re Delhi case, the same case, the very famous case, right? Now the constitutional permissibility, what are the provision or how the constitution, our constitution allows parliament to delegate, right? So I've already discussed itself, I have written that itself. I've compared it with the USA also, right? No wide delegation is permissible, right? So they've simply said now everything has to pass from Congress, but here the wide delegation have been permissible, but not wider as in England. See, the parliament is supreme and has been able to confer wide legislative power, right? Delegation is wide, so we are somewhere in between US and UK, somewhere in between. Okay, that I have just discussed earlier. Okay, so I have written that, right? There is nothing in the constitution expressly prohibiting the legislature to delegate. Therefore, if the court has to find any restriction on the legislature in the matter of delegation, it has to be on the basis of some general theories, right? The general theory is excessive delegation. Essential function cannot be delegated, and that general theories was based on that particular case law in Redeli. Okay, principle of constitutional law. Okay, in Redeli, see, Bible of the delegated legislation. It was an act of judicial creativity on the part of Supreme Court to adopt the doctrine of excessive delegation, right? Sometime there have been a philosophical question that the doctrine of excessive delegation is a judicially carved principle. Comment, right? So you have to talk about UK, you have to talk about USA, and then you have to say that India adopted more flexible approach. They did not give as wide discretion as applicable in the case of UK, did not the limit it down as applicable in the case of your US. Okay, right? So that particular thing has to be kept in mind. Okay, and you have to write that answers accordingly. Okay, now let us see some of the previous year paper. It was a 7 judge. Yes, it was a full judge bench. Yes, I have been saying it wrong. It was a full judge because when the constitution was committed, it was the whole seven judge itself. Okay. Yes, Akanksha, very nice. Thank you. Okay. Now let us start with the previous paper. Right. Let us see some of the questions of the previous paper. See, the rule of law is based on the principle of legality and opposed to the exercise of arbitrary power. Right. So that is basically the philosophical aspect of administrative law. Okay, so even there is not a question, still the rule of law comes. So you have to find the relationship between rule of law and administrative law. Okay, it is not given directly in syllabus, but still question have been there. This also here also there have been a question regarding rule of law. Okay, so you have to read that. Justice should not be done, but it shall also manifestly and undoubtedly be seen to be done. Now this is a question where we will put this question. Is it a question of constitutionalism? Is it a question of judiciary, or is it a question of administrative law? Right? So UPSC sometimes tends to give you, fox you that okay, you try to find out that which topic this question relates to. That thing you cannot find ever in judicial, paper exams. No, you can practically pinpoint. Okay, this is a question related to this law. Now, where do you find this question? Yes, can anyone guess it? PNJ, or what about this judicial activism? What is the problem in that? Or PIL? What is the problem in PIL? Why can't you put that question in PIL? See, can't you say one of the aspects of the PIL is to deliver justice, bringing people closer to the court? That can be there. Okay, so that type of question comes, right? So you have to there make a better judgment. But you are right here. Obviously, I have given here in PNG, so this is in the PNG actually. Okay, good. Then, are the principle of natural justice embodied rule of the Constitution of India having characteristics of due process of law? That 1421 connection with PNJ, okay, that I have already told you. Tulsi Ram Patel, you can cite the example of 311, right? Exact answer that I have almost provided in the beginning. Then, the dividing line between the administrative power and the quasi-judicial power is quite thin and is being gradually obliterated. If purpose of the rule of natural justice is to prevent miscarriage of justice, one fails to see why those rules should be made applicable to administrative inquiries. Okay, because they are assuming that administrative inquiries by default deliver justice, so they need not to adhere to certain principles. Obviously, that that is why I keep telling you that in the UPSC question is more supportive of executive, right? They are more of criticizing judiciary. Okay, more supportive of executive. I've told you in the first class itself if you have attended that, right? So that is basically saying that whatever we are doing, executive is okay. Why we need to adhere to PNJ, right? So obviously you have to write argument against it. Okay. Okay. Let me first complete, right? And this video will be uploaded after 4 or 5 days. Okay, you re-watch it again. Okay, I will not repeat everything again and again, right? Raise your hand after the class, then I will try to solve your. Okay. The concept of natural justice is elastic, very flexible. It is not susceptible to precise definition. Discuss. Well, a philosophical type question, you can cite any case law actually, where you can cite that okay, in a similar case the court have have resulted into a different opinion. In one cases the court, the same cases, similar circumstances, the court have went into different opinion, right? And then you can drive the argument home that okay, the PNJ are not a strict sense of rule, it is basically flexible in nature. Okay, so that argument can be derived. Okay, so again this part, this question you will try to write. Now see, policy and guideline theory presupposes the delivery of justice by quasi-judicial authority. Okay, so it means that a guideline is given, a policy is given, then the delegation is okay. That is what the policy and guideline is. It means what this particular theory assumes that if the delegative authority have given some guideline, right, have trusted the executive, right, then the court should not go into it. They should only check whether the guideline is there or not. That's it. Okay, so that is the point. Presupposes the delivery of justice. It means that if this guideline is there, then the justice will be delivered, right? So the court should not inquire into it. Okay, so that is the question, right? Again, in support of executive, right? Then the doctrine of excessive delegation is a judicially tailored principle. This is the question that you have to write actually, right? You read that in Delhi case judgment, right? And try to write this particular answer for today. Okay, and then you can discuss multiple aspect of it, right? You can discuss multiple aspect of it, right? You can talk about that how in Parliament of Britain the things have changed, right? Things were there, how India adopted a different approach. Then you can say that nothing in the constitution is there to control delegative legislation, right? So this principle of controlling delegative legislation basically comes from case laws. Then you can cite case laws mainly in Delhi cases and multiple judges view, right? And then you can finally commit it is a judicially tailored principle. Okay, right? So not given anywhere in India, it have been crystallized by judiciary. Okay, so that is the question that you have to write for today, right? Question number 7. Do remember it. Okay, everyone. Yes. Now let me check your answers, and then we will take some of the questions. Okay. Yes. Let us start with the answers. Let me drink some water first. Yes. Now this is one of the question. Again, this question, this guy have sent the wrong question, right? If you're saying wrong question, I will not choose your answer. So, okay. So please solve only the questions that I give you, right? Not the other ones, right? So this I will be not checking. I have mistakenly taking this, I suppose. Yes, let us come to this question then. What restrictions have been imposed by the constitutional amendment? Okay, this was the question. Very good. So 44th amendment, number of changes. You start with how it was misused by 42nd amendment. Then write that as a result 44th amendment tried to soften those changes. Okay, so that particular thing you have to write. 75 situation. Achha, you have written later on. You could have written, but that's okay. That is simply the framing. Restriction imposed by, okay. Improvements ज़्यादा word होता है. Internal response replaced by armed rebellion. You write why, okay, because it is susceptible to very broad definition, right? So we wanted a targeted one. Written advice, okay, good, very good, okay. It was there as well. It was there, I think, before 44th also. Yes, this is the main point actually. That sometimes what happens that the Lok Sabha speaker might not call the session because he is the government guy, right? So if a quorum gives a notice of Lok Sabha speaker to assemble it, then the session will be assembled, to pass the decision against this emergency. Very significant. Okay. Unbendable power. Yes, good content actually, right? To the point. Okay. Now I have taken 2 copies here. I suppose one copy is gone. Okay, no problem. Let us evaluate one itself, right? So I have taken 2 copies. This copy mistakenly I have taken actually, but no problem. I will have it in another way. No problem. Now let me, because this question was also easy, right? So you can easily understand this. but write that judicially tailored principle, right? Because that is something you can prepare a model answer and that will come in exam. Okay, now I will invite questions from you all. Any questions you have, please go ahead. Please raise your hand and I will try to answer the questions. Okay. No, I will not give. I have explained that. That will be sufficient, not more than that. Okay, Mr. User. Yes, Navneet, go ahead.
Good afternoon, sir.
Good afternoon.
Sir, there is one of the principles of natural justice that no one will be a judge in its own cause. But when we take the example of administrative authorities, one, there is a person who has been wronged and other is a deciding authority. The administrative authority itself is the deciding authority by which the person is wronged. So isn't that a violation of natural justice?
If the person who have wronged you and he is also the administrative authority, that will vitiate the proceeding itself. That cannot happen.
So, but administrative authority is taking the decision.
If the administrative, suppose I am the DM, right, and I have suspended you, I cannot sit in administrative, in inquiry. I cannot sit at all. Even if I am the boss, I cannot sit.
Okay.
And if it has happened, it is the VHSN. You should file a writ, and that particular whole proceeding will be quashed.
Okay, sir. Okay, sir. Thank you, sir.
Okay, so I think no more questions for today, right? Already we have 45 minutes. Today we had a long discussion. We had a large, number of, the whole administrative law almost we discussed in this 30-40 minutes. Okay, so tomorrow, master of roaster, Adil is saying, yes. In the case of master of roaster, the court said that I am the boss, I am the administrative authority, I can do whatever I want, right? And because the buck stops there, so you cannot do anything actually, right? So to answer your question, Adil, the court is the boss. Supreme Court is the boss. Yes, you can write here. Situation like COVID-19. Yes, you can write here. You can write. Yes, user, you are very correct. Today's question I have already given you. Where were you? Today's question is the last one. Yes, see. Question number 7 is the today's question. Okay. Yes, Mr. SS, go ahead. Ask your question. Can you hear me, Mr. SS? No? No. Okay. Yes, Mr. John Wick.
Good afternoon, sir.
Good afternoon. Go ahead.
Sir, I want to just ask that there is a question answer sheet that you are reflecting on your screen. We are on emergency. It is quite related to the topic that you have given. Mistakenly, it has been written wrong on a wrong question. But it is quite resembling to the question that has been given by you.
No.
So can you please describe it?
That will lead to a situation that people writing their own answers and I have to evaluate everyone. That will not happen. So whatever the question I am giving you, just write that and that is only I will check. Nothing else. Okay?
Okay.
If you want this copy, I will email to you. You can read by themselves. Okay? And if you have still some question, you can email me back. Okay?
Okay, sir. Okay.
So that will be all for today. Thank you very much and